ibarristerschambers.com. A visitor's visa permits a stay of up to 6 months in the UK. It does not permit work, significant study or commercial activities to be carried out. The starting point is the immigration rules, so let's have a look at Rule 41, where most of the requirements are set out. As soon as we look at Rule 41, we can see that most of the requirements are phrased in terms of the intention of the applicant. This can make it rather difficult to prove, and it means that the entry clearance officer or the immigration official is exercising a high degree of subjective judgment about whether to grant the visa or not. The first requirement is that the applicant genuinely seeks entry for the limited period stated in the application, and secondly, that it's that person's intention to leave the United Kingdom at the end of that stated period of visit, and they don't intend to live for extended periods in the United Kingdom through frequent or successive visits. If an application comes after a number of successive visits to the United Kingdom, it may be necessary to give some thought as to what evidence can go before the entry clearance officer to assure them that that's not the intention. Otherwise, one may find that a visa is refused under subparagraph 2. Thirdly, it must not be the applicant's intention to take employment in the United Kingdom, or 4, does not intend to produce goods or provide services within the United Kingdom, and that includes the selling of goods and services to members of the public, even in a very informal way, for example on the street. The 5th subparagraph says that it must not be the applicant's intention to undertake a course of study. Well, in fact, there are informal study options available to visitors. There are more details on ibarristerschambers.com website. There are also visa options which allow business and work to be carried out in the UK, but they're different visas, and again, details are on ibarristerschambers.com website. The 6th requirement is that the applicant will maintain and accommodate himself and dependents adequately out of resources available to him without recourse to public funds or taking employment. The applicant may rely on evidence that there will be funds or maintenance and accommodation provided by relatives or friends who are in the UK. Those people are called sponsors in the application. The applicant will have to show that they can meet the cost of returning to their country or onward travel away from the United Kingdom at the end of their visit. And I'm not going to read everything out, but looking at subparagraph 10, the applicant must not during their visit intend to marry or form a civil partnership, and must not intend to receive private medical treatment during the visit. By the way, I mentioned the ibarristers.com website. Here it is. If you look at it, go to the bottom of the home page, you'll see a number of buttons relating to different kinds of visas. Click on those buttons and you'll get more information relating to the different visa categories. We've already noted the emphasis given by the rules to the intention of an applicant. In fact, the reasons most commonly given by entry clearance officers for refusing visit visas relate to their suspicion that an applicant either doesn't intend to leave the UK or intends to work whilst in the UK. Applications can be strengthened by giving proper consideration to what evidence there may be to support an applicant's stated intention. For example, if you've made arrangements with your employers for a limited period of leave to resume work at a certain time, then a statement or letter from employers will help. The gov.uk website contains information about the visa application process. It also contains a link to the Immigration and Visas site from where most applications are made. The exception is applicants from Cuba and North Korea, for whom different regulations apply. They must apply on paper. These sites also contain a link to information about the fees which attach to various visa applications. If an application is refused, there are several courses open to the applicant. They can request reconsideration, or they can reapply, or in some limited circumstances they can appeal to the courts or seek judicial review. At this point, many applicants seek legal advice, as the procedure can be complex and difficult to participate in from abroad. But broadly, if it's the case that the entry clearance officer has just overlooked or misinterpreted the significance of documents which have already been submitted, a request for reconsideration may be the appropriate route. You should also enclose any further supporting documents with that request. If there's new evidence, it may be better and quicker to reapply, enclosing all the relevant materials. But there are some cases where an appeal or a judicial review will be necessary. For example, if there are doubts about the applicant's intention to leave the United Kingdom, it may be that an appeal is the best way of addressing such issues. Also, if the refusal states that the applicant has been excluded from the UK, or if there are findings about deception by the entry clearance officer, it is particularly important then that they are put right by appeal, as they'll adversely affect your prospect of gaining entry in the future. If an appeal is appropriate, great care needs to be taken to ensure that the relevant time limits and directions are complied with. Appeal forms are available online at the Tribunal website, where the process is also described. I, barristers, wish you the best of luck in obtaining your visa. If you would like professional advice or assistance at any stage in the process, please visit our website www.ibarristerschambers.com, where you'll find a contact and inquiry form and also further information about this and other types of UK visa.